You have to, pardon me, I asked for the same consideration from the JSPA. I don't know how long I can stand. I don't know. Some of you are aware of my recent issue. Probably standing would just make my blood pressure go up and things may not go well. So I won't tell the joke until the sheriff's office. Okay, first of all, I represent not only my community, I represent a wider community. And I want to set the record straight that we are not opposed to any of this concept. Matter of fact, we stood out against several of the councilmen and others in the county when the MIDA project was proposed. That we saw that there was quite a bit of merit for MIDA promoting the development of this area that's been lacking for the last 15, 20 years. So I view that the people that I talk to every day are supporters of this. However, we have a real problem with the process. And again, pardon me. And so I'll read the opening statement. I'm sorry that my wife could not be here. She's one of the attorneys who've been working on this. We've offered general counsel or the county counsel, county attorney's office, to discuss the legal issues with them, and they've come back absolutely silent. And I still offer that we can go through the individual issues, but there's no discussion. There's absolutely none. Okay, so let's go through what I've written, and I'm going to read it out in entirety. It's just one page, because there are three other members of the community here that do not have copies of this. I'll send you copies tonight. Okay, I introduced myself. We, meaning my wife and I, have submitted written comments to the JSPA Planning Commission relative to the meeting it held on August 8th via the Planning Department through Doug. And we've submitted written comments to the County Council regarding this meeting, also through Doug. I'm giving a copy to each of you and to the recorder so that they can be made part of the record. Nothing that I've done so far that I've seen has been in the record. We have specific comments regarding each of the proposals tonight. And we also have threshold concerns as to the legality of the Planning Commission hearing that was held on August 8th. I'll have some relatively minor substantive comments on the point. I do not know whether they've been included or not. I have to look to Doug. I'll go through those comments after I'm done with this. Specific comments on this, and I'd appreciate if you could go back to your first diagram, if you would.
I didn't see that. I don't know, Council, the public hearing is on this project. Does this statement have to do with
Well, I would give this statement normally in the beginning, but I was, sort of written off by Mike Davis saying that, his legal counsel there already reviewed it and saw no problems. And you, as the county council, has to vote on this, and you have to know what deep water you're getting into. So if you want me, I apologize if I didn't interrupt you in the beginning to go through my objections. This is the only time I've seen the opportunity to do so.
Well, I think the statement...
Can I sit down, because I'm sorry, the world's starting to spin.
The statement Mr. Davis made was that we recognize that we have this document and it pertained to this.
Okay, but does that preclude me from giving testimony on that?
Well,
No.
No, I guess not.
Okay, I only have this one page, and then we'll get into substantive discussions on the point. Again, we're not arguing about the substance of many things that are occurring here. We just don't like the procedures that are being used. Okay, as outlined in our comments, this is the fourth paragraph, this meeting in the public hearing was not properly noticed. In my community, when we made changes, we had to go out, and I had to give 35 letters to the planning department to notice a public hearing. I've received, and I own 2 properties there, I've received no notice of the meeting tonight, no notice of the public, of the Planning Commission meeting. There was only the advertisement in the newspaper. I'm due a written notice that you're making changes to the master plan for my community. I'm sorry, I was being interrupted during my testimony at the Planning Commission. I have to object to that. As you know, you would object to me speaking to somebody else in the audience, so I believe I'm due the same courtesy that you would demand of me. Okay, the county shall mail notice to the hearing to each affected entity, each property owner whose land is affected by a land use change, and each adjacent property owner at least 10 days before the public hearing. I qualify as a property owner who is entitled to written notice delivered by the mail. I've received no such notice. Neither did any other affected property to whom I have spoken. Therefore, the notice is defective and you can't proceed tonight. As outlined in our comments, County Council may not act upon a recommendation of the JSPA Planning Commission that occurred on August 8th until it receives the official record of that meeting. Section 52.4-203 of the Utah Public Open Meeting Act clearly states that no official record of a public meeting exists until the minutes have been approved by the public body holding the meeting. This is the same conditions that apply to you. No minutes have been approved by the JSPA for that meeting held on August 8th. Therefore, reports of action which were signed by Mr. Rosecrans do not qualify as the official record of that meeting. Because you have not received the official minutes of that meeting, you can't address anything that they discussed that night. Finally, County Council may not act on any recommendations from the JSPA Planning Commission because the terms of 2 of its members who participated in the meeting had expired prior to August 8th. As per the Supreme Court case, recent one, National Labor Relations Board versus Noel Canning, which was decided in 2014, decisions reached by individuals who are not legally occupying their positions are null and void. Those 2 members were not in legal possession of their seats at that time. And you have to confirm, we got the cart before the horse here, because as part of the Mike Davis's discussions tonight would be his proposal to reinstate 2 of those members. So all decisions on August 8th are null. Okay, so you have this. I again offer the suggestion that the lawyers sit down and talk about this. We've received no explanation of why we're wrong in our interpretation. And I gave an example of an exact analogous situation that occurs in Summit County, and that is Vail developing the Canyons Resort. They have a planning commission for the Snyderville Basin. That basin, or that commission, is populated by residents of the Snyderville Basin. They also have a design recommendation team, who essentially are the same types of people that you have for this planning commission. So your neighboring county is legally going through the process that was established by the state to involve the public in the consideration of development. And I was told that wasn't relevant by Mr. Rosecrans, who is interesting that he served in the Snyderville Basin on one of their water commissions. So he's well aware of the existence and the use of these commissions and who they're populated by. So I beat the dead horse enough here. You're not acting legally. We have options. We'll consider our options. We have always agreed to sit down and talk with you. Again, we are not at odds at the development of the JSPA. We're not at odds. We have questions on individual things, as I'll give you now. Okay. I'd like to know if in those 19 points were included, that we gave testimony on August 8th. The first one was fairly straightforward. The contractor for the point had blanket statements as to there's no wetlands there and they have no effect on water quality. I've reviewed an awful lot of official documents in my capacity. Kit, in her legal capacity, has also done that for the other side, for developers. Unless there is an overall study done by the Corps of Engineers or by the EPA or the state acting for the EPA, that's really not appropriate for the contractor to state that. But that's fairly minor. The second issue is that affordable housing. We learned at the meeting, and it was new to the commissioners, that the affordable housing requirement for this has been negotiated, probably too strong a term, but has been discussed between our mountain lands represented and them, that they would do a fee in lieu of because of this, what you've already decided on how to handle affordable housing for the lakeside north. And I asked, well, what is the fee in lieu of? And the answer came back, and is it still? It's $28,000. We're having 150 homes put up there, and they're going to get away with paying $28,000 times 15. Or is my number wrong? If my number's wrong, I apologize. But this is an example of the need to pass the legislation on affordable housing, because everybody here is going to claim that they're grandfather, other than those that you require to build affordable housing on site. The last issue, and I'd asked if you could go back to the first one because I'm familiar. Right there. Yeah, either one of those. Where that blue splotch is right there, thank you. And you know, I've been here pestering you for the last, 3-4 years about people camping and shooting up there. That blue is right where there's a berm that's about 15 feet high. That berm is absolutely loaded with thousands of rounds of lead-containing ammunition. Now, I testified at the Planning Commission that I belonged to 2 shooting clubs that had to reclaim their shooting range because of the situation that we have here. And I've collected some shells there that have been fired just in the last 2 months. And there must have been, there's over 1,000 rounds fired just in the last 2 months. That it should be in recommendation that they do some remediation of that berm for all the lead there. And the comment I made was, there's more lead in that berm than there is in several acres of land that's being reclaimed presently by Steeching Mayflower. They're talking about parts per million in the soil that's being reclaimed. We're talking about here, depending upon whether you sample, percentages. So I would appreciate that we include that in there. That is not a killer issue. So I don't know, I have to ask, were any of those items included in the 19 points? If they were not, then I don't know why I bothered to testify at public hearings. I don't know why we have public hearings. Just have your design recommendation team meet and make the decisions.
I can't add a condition to that. If the Planning Commission wants to add a condition and follow your recommendations, they can do that. They didn't.
Well, that's interesting because they follow your, no, I'm sorry, I shouldn't be speaking. They follow the recommendations pretty much in line, toe-to-toe, line for line, of the planning director, as you know they should. Okay? And I think these are valid points that should be included. So I appealed to them. I don't know what happened because some of the votes they took were mixed. They didn't agree. They didn't all agree and didn't vote on some issues, and yet they're here before you tonight. Now, not on this one, but it's like I am an expert on some of these things. I am an expert more so than any other people that were in the room. And yet, you know, nothing is considered. So I'll look at my options, but I offer you, again, on the legal issues that the attorneys meet and hash through, because we want to see this done. We really do. But if you leave the public out of this, there's going to be a price to be paid by all of us, and that includes me, sometime down the road when they ask, well, why did this happen? And I'm going to say, it's just like it was, and remember the bad old days 4 years ago, when people, when the chairman would interrupt my testimony, and I don't want us to ever return to that. So these are my comments on this section. And thank you for allowing me to speak. And I'm just sorry that we don't have more members of the public here to come before you tonight.
Okay, thank you. Any other members of the public who would questions or comments? Seeing none, we will close the public hearing on this item, and council, we're back to you.
Just back to the one question on affordable housing on the fee in lieu. Didn't we have a pending ordinance in place, and didn't we just renew that pending ordinance that they would be subject to the new affordable housing fee in lieu?
Well, the pending ordinance, my understanding was for the new code, but there was never a decision on the fee in lieu. I guess we'd have to look to legal to see if they're under that and would therefore have to comply with the new $81,000.
Yeah, that we were going to review the fee in lieu amount.
We're well going forward. I don't know whether.
And maybe they are under that, and they'll have to pay the new amount.
We did that 6 months ago, and then we just renewed it again.
Yeah, you did. You're right.
There's a provision in our code that says the current fee in lieu has to be paid, and we've had back and forth with the developers, not this particular developer, but with other developers. There's arguments on both sides there. One thing that I know is in the conditions that Doug put together, it says approval by the county council of the concept to satisfy the affordable housing requirement by paying fee in lieu. That leaves you guys in the loop. So you guys have a say in what that fee in lieu is and what, if you're going to accept a fee in lieu at all.
That's what I'm going to say. They meet and it refers here to Mountain Land, which is Scott Loomis. But he just gives them potential possibilities that what we accept comes back to the council. What's the name of
I was going to say, that decision has not even been addressed.
You mean
Whether
what?
they pay fee in lieu or build on site or build
No,
on
as I
site.
thought that when I saw it.
Literally,
We
it
haven't even talked about it.
cannot legally be addressed till it's brought to you. That's not something Scott Loomis can discuss with them. It's not anything the JSPA Planning Commission can discuss. It's not in their authority. This is your issue only.
Scott can give them potential ideas, but the decision's got to be made here.
Right, but the decision of whether they do it or not, you should be making.
Correct.
And that was the intent with that condition, is they're proposing you pay a fee in lieu, but it's up to you.
Okay, any other questions? No? We have a motion? Close the public hearing. Yeah.
I make a motion to close the public hearing.
You don't have to make a motion, we closed it.
Okay. What are you mumbling about?
I'm not, I said we closed the public hearing. It's back to you, council, for a motion or whatever you want to do. There's some discussion of possibly continue it or deny it or...
I'm not sure what good to do to continue. We've got the recommendation from the planning department, the recommendation from the planning,
JSPA.
everybody. Suggesting that we move it on. This is just master plan. There's a lot of conditions and findings that need to be met in order for it to ever be built. You've got to meet the development agreement. It needs to still be written. and approved by us, I would imagine. So this is just master plan to kind of give them a little direction. They're not asking for bonus density. They meet current code requests, it sounds like, and the road has been addressed as well. So part of the master plan approval probably meets that. And when they come back for final approval, they have to have all their conditions and findings met. And if they were to flip the property and sell it, they would have to have the development agreement in place, I would imagine, that would dictate how it's going to be developed and built, and they couldn't ask for increased density or anything else. So, kind of my understanding on where we're at. Is that about right, Doug? Yeah, other than that, if you do move forward and propose to approve the master plan, I haven't gone through and got on record all the conditions and the findings and all that, so depending on how you want to handle that.
So there's more than what that's listed here?
No, there's not, but typically I go through those and they're put on in the minutes and all that. But
By approving master plan, we're giving them entitlement for 173 ERUs and 160 buildings.
well, no, what's proposed is 123 ERUs and 160 units.
160 units.
So, yeah.
There is some entitlement going along with this master plan.
Yes, there is.
On the conditions, I mean, we talked about this a minute ago. Item number 9, a letter from Mountain Lands Housing Trust regarding the moderate income housing plan. I don't know whether we're set up that we get a letter from them, or is that, I mean, I know we're working on who's going to do that, and who's going to review that. So that's maybe okay. Then item number 17 talks about that again, and I don't like the wording of that based on what we just said. Approval by the county council of the concept to satisfy the affordable housing requirement, period. I don't like the by paying a fee in lieu, because we don't know. I mean, that's one of the proposals that could come to us as a council to decide, are you going to do a fee in lieu, or are we going to require you to build on-site or off-site, or whatever that ends up being. But it seems like that line, by paying a fee in lieu, kind of suggests that that's the option that we accept. So I like that. I don't know what the rest think, but I think maybe either reword it or put a period after requirement, then taken off by paying a fee in lieu.
Well, you need to understand, if you approve this master plan, you are approving the affordable housing.
Which we don't have yet.
I understand that. But just so that you understand, if you're approving this, you are approving the affordable housing, because if you are to require it to be built on site, that changes the master plan.
Yeah.
So
maybe given that, it's not ready, as our other things aren't ready.
Mr. Chairman, I make the motion, we table this matter indefinitely until we get some of the answer to conditions and some of the questions that have been brought up here at the meeting tonight, and send it back to the applicant to resolve some of the issues before we give any entitlement on master plan.
Do we want to add, consideration of what Mr. Kuskowski said on the land reclamation? Do we need added the condition of it? I think that's something we're looking at if there's really much there as it's presented. The lead in that berm. And then there was a question on road profile, which could be possibly another condition.
I think that was taken care of.
You think it was up in?
I'll second that motion.
Okay, we have a motion to table this until it goes back to the applicant to work out some of the details, some of the issues in the conditions. We have a motion and a second. Any other discussion? See none, we'll vote. Yes.
Yes.